Thank you, everybody, for coming tonight to the event, the Know Your Rights event, your right to humane treatment while incarcerated. Just like to say thank you to those of you who came in person and those out in Zoom for attending. Tonight, we will be discussing the legal rights, medical care, and public benefits. And so my name is Terrell Mosley. I am a community outreach coordinator for PILP. I'm also a legal assistant. And I'll tell you a little about myself, how I, came to start in this. So I was previously incarcerated at one point in time. And, it had a drastic, lasting impression on my life. So this really hits home for me as far as the rights to while you're incarcerated. So, with that being said, I had came across when I was incarcerated, just not knowing, what my rights were. And it was detrimental because the one thing that while you're incarcerated is hope. You want to have some kind of hope. And in my circumstance, like I was charged and I was locked up, but I never was put in front of a judge. I was never talked to as far as, them letting me know what was going to happen with me. So I actually wrote to PILP back when I was 19 years old. And the one thing that they gave me was they gave me information. And that information was like my lasting saving grace. Just the comfort of knowing like what, can and can't be done to an individual while you're incarcerated. It speaks volumes. So with that being said, I'll turn it over to Humane, our director, and she'll proceed. Thank you.
Good evening, everyone. Thank you so much for attending today. And I know we have some people in person and some people on Zoom. This is our first ever Know Your Rights session. So we're really delighted. We're really excited to reach out to folks. And so the purpose of this evening is really geared towards friends, families, advocates and not necessarily lawyers, but it might be lawyers, but people who, if you know someone who's behind bars, and we are here really to try to help expand the knowledge base so that you know what your rights are if you are incarcerated. So with that in mind, there's a lot to cover. And basically, if you have other questions, feel free to use the Q&A. And I just have to apologize in advance for any tech issues. We have the Q&As on the laptop over there, and we're speaking over here. But definitely, you can either, if you're in person, let us know, or we'll take the Q&A and chat. So in terms of this evening, I'm Sue Mignet. I'm the executive director of the Pennsylvania Institutional Law Project. And what we do is we advance the constitutional civil rights of people who are incarcerated, seeking to ensure that people are treated humanely, that they have access to medical care, that they are safe from violence, that they have their disabilities accommodated and the ability to observe their religion, that people are free from retaliation and have access to the courts. So we are a legal aid provider where we serve the entire state of Pennsylvania, whether you are in a state prison, a federal prison, a county jail, an immigration detention center, a halfway house. We are here for you to try to help. And so part of that is talking through the different issues today. And it may be, I kind of took a little bit of a look at the list. It looks like some of you may be well familiar, but hopefully you can get something out of today as well. So what I'm going to do is I'm going to start off, then I'm going to turn it over to Evangeline Wright, who is our new attorney in our Central Pennsylvania office, which is located in Lewisburg. And then as you just heard, you heard from Terrell Mosley. I'm really grateful for him for behind the scenes organizing this. Then you'll hear from Ricardo Brown-Witt, who will talk a little bit about public benefits and access, barriers to employment. And then closing it up will be Chester Holman, who is another staff person at PILP. All right, so just to get started, let's see. I'm trying to fast forward the PowerPoint.
Microphone's on because it doesn't sound as though it's on.
I don't know, but that might be going to the Zoom.
Okay.
Do you need us to speak?
Well, it would help if you could speak up a little bit.
Okay.
The room is big.
Sure. I'm trying to figure out how to move the PowerPoint. Oh, no. There we go. Okay. So this is just our contact information. All right. So what is the basis of your right to humane treatment? And basically, there are different sources of your rights. And the primary one is the United States Constitution. When this country was founded, there is a prohibition against cruel, unusual punishment. And under the 14th Amendment, that then carries over to people who are being held pre-trial or in some other institution, whether you're in immigration detention or whether you're being held pre-trial in a jail. Okay. And then also on top of that, there's federal law that also applies to people who are incarcerated. So you may have heard of the ADA, the Americans with Disabilities Act. Well, that also applies to people who are incarcerated. And there are a number of other laws that also cover and provide rights to people who are incarcerated. And the way you bring these cases into court, sometimes you hear people who are incarcerated say, oh, I'm going to file in 1983. That refers to a specific law, 42 USC 1983. And that's just your key to the courthouse, your ability to bring a case into court. And then last, I wanted to put here state law. State law does provide you some rights. So for example, in the medical care context, there's a medical standard of care. And yes, that does apply to jails and prisons and all other institutions. Now, the practical part is that it can be hard to bring those state law cases, but you do have rights under state law. And you might have other rights that aren't necessarily in the Constitution. For example, your right to outdoor recreation is through Pennsylvania statute and not necessarily a constitutional law. So all of these combined together become a source of very important rights, the right to be humanely treated while you are incarcerated. So I'm going to start off by looking at just humane conditions. You have a right to safe and sanitary conditions while you're incarcerated, but it's not just one thing. You have to look at all the conditions combined. And so I used to have a client who said, yes, I know I'm not entitled to live in a hotel, but I am entitled to have some semblance of safety and a clean environment while I'm incarcerated. So courts, when they look at this and when we are bringing cases, we'll have to look at sanitation, fire safety. Is the heating system working? Is the air conditioning working? Are basic supplies being provided, like toilet paper, soap, things like that? How is the medical treatment? Are there large delays? Is it safe? Infestations. Now, one infestation, let's say you have a lot of cockroaches, a lot of mice. We hear this complaint all the time. One thing is not going to make you're not going to win in court just because there happened to be one mouse, but it's part of the overall picture, right? And it absolutely, vermin and insects affect the health and safety of people who are incarcerated. Overcrowding, a lot of the, as the population went up, you have a lot of people in a small location, and that can really impact people's conditions. But overcrowding alone, just having 3 people in a cell, doesn't necessarily make for unconstitutional or unlawful illegal conditions. But again, it's part of it. What we are hearing nowadays is not just overcrowding, but kind of a link to that, which is understaffing. So it's kind of like an overcrowding issue. There might be enough space, but there aren't enough staff to ensure that the numbers of people who are there are held safely and humanely. It might lead to delays. I think this is an issue all across Pennsylvania. I'm based in Philadelphia, and especially the Philadelphia jails, but we are hearing this all across as an understaffing issue and impacting people's access to necessary services. And another vital component is, lockdowns, out of cell time. Are you able to have freedom of movement, interact with others? Because we now know solitary confinement, being by yourself for hours on end, if you're only allowed out for 15 minutes a day, that is detrimental to your physical and mental health. The next area is safety from violence. You absolutely have the right to be safe from violence while you're incarcerated. And I kind of look at this as 2 groupings. One is excessive force and sexual abuse. And that is where the violence or the force comes from people who work for the prison. And then there is the failure to protect end, where the staff have failed to protect you from some sort of violence. And that might be from another incarcerated person, or on occasion it could be, from another staff person. These are legally a little bit different, but they're both incredibly important from the perspective of the person who's incarcerated, right? If you are subjected to violence, in some ways, both of those are horrific. So excessive force is what we call it generally when someone is, when violence is inflicted by a prison staff person. And just to note, there are kind of two legal standards, and I just want to flag that because if you are incarcerated, it does make a difference in this case, whether you have a criminal conviction or if you are awaiting trial. And so basically, if you already are serving your sentence for a criminal conviction, the courts have really looked at whether the force was used to maintain or restore discipline or was used maliciously or sadistically to cause harm. And honestly, this can sometimes be hard because what we hear a lot, and you may have experienced, is the prison staff will say, oh, well, they did something that I was fearful, I had to use force. And here's the thing, the prisons are legally allowed to use force. They can't just use excessive force. And so you often then have a he said situation of what happened. And it can be hard to prove that the force used was malicious and sadistic. And also it varies by perspective, definitely. Okay. But if you are awaiting trial, you are in a different category, a different status, because you have not been legally found guilty, and you are presumed innocent. So the legal standard is something called objectively unreasonable. So was the force used objectively unreasonable? And in lawyers speak, what that means is it's much easier to show that something was unreasonable. Like you can imagine a prison guard, what they did was completely unreasonable, but was it malicious? Was it sadistic? And that's sometimes where there can be a difference. All right. And generally sexual abuse falls under the category of excessive force. And I will say there's never a good reason for there to be sexual abuse. So it sometimes is much easier to meet that malicious and sadistic prong for sexual abuse. Unfortunately, we do get a lot of reports of that, and we have brought a number of cases on behalf of clients. All right, so the other side of this is the failure to protect issue, which is someone else has either assaulted you or done something, and the prison failed to protect you. This sometimes can be tough as well. And what you will see here is this is our first reference to this term deliberate indifference, and you'll hear it in other contexts. And so we don't have a lot of cases here, but this is one case that's pretty important from the Supreme Court, Farmer versus Brennan, that basically established this. And so it showed, in order to win a case, you have to show a prison official knew of and disregarded excessive risk. So let's talk about what this means. So, we had one client who was in a cell with someone else and was fearful of that cellmate, reported it. The prison did act, moved that person, and this was at United States Penitentiary Lewisburg, moved that person out of the cell, but kept them on the same block. So they knew that there might be a risk because our client told the prison, hey, I'm fearful of my cellmate. And then did they disregard, by moving them, did they address it or not? And so we argue that keeping that person on the same block was not a reasonable step, that they should have separated them completely, because unfortunately what happened was our client was then assaulted by this other incarcerated person while they, during the short time they had for the shower, and brutally so, unfortunately. And our client ended up with a permanent, facial scar and drool. So we had to look at whether or not the prison's actions was reasonable, and did they disregard that risk to our client's health and safety. What can be hard about these cases is, and sometimes if you are talking and consulting with us, we will ask, did the prison know, was there any kind of notice? And so any kind of notice that's in writing is always the most helpful. And I'll say, we get a lot of reports, and we generally believe when people come to us and say, I told the prison, because, you know, usually you have. The challenge is, as you go through a case, us as lawyers, how do we prove it? And as you may know, when you bring a lawsuit in federal court, you're going to end up ultimately in front of a federal jury. And if there's no paperwork, there's no paper trail, it's going to be who does the jury believe, whether is that you or is it the correctional officer who said, I never got any notice. So we encourage, if you know, and we completely understand that at times by reporting something, you yourself may be fearful of retaliation, and that is only something that you can weigh. But in order for you to be protected under this standard, there has to be some sort of notice. Now, there are some exceptions where is sometimes the status of an individual, people, you know, some certain categories of people are going to be more known to be vulnerable, whether did you, you know, quote unquote, were you a snitch, LGBTQ folks who are incarcerated. There are different categories of people that the prisons know, should know, and do know are going to be more vulnerable. And so therefore they do need to take steps to ensure their safety. Okay, so I'm just going to jump ahead to disability accommodations. As I said before, the ADA and the corresponding law, you may or may not have heard of the Rehabilitation Act, both of those apply to people who are incarcerated. And so they have an obligation, prisons, jails, detention centers, all have an obligation to provide reasonable accommodations for disability. So just very quickly, you have to kind of show that you're disabled, but disability, you know, can what does that mean? It means, do you have some sort of impairment, a limitation that affects one or, you know, substantially limits one or more of your major life activities? And that can actually be not as hard as you might think. You know, we typically think of people with disabilities, blind, deaf, you know, no leg, but actually, does your disability affect your ability to sleep, concentrate? So physical and mental and psychiatric disabilities are all included into this. And does that impairment prevent you from participating in a program, service, or activity? Does it prevent you from going to your religious services? Does it prevent you from going to talk to your counselor? Does it prevent you from going to chow hall? All of those things can count as a program, service, or activity. And the other way you can show that the ADA is being violated is, are you being discriminated by reason of your disability? You know, is it because of your disabilities that you can't do all these things? All right, so just skipping forward, you know, you also have the right to observe your religion, and there are two sources of this right. One is the U.S. Constitution, the First Amendment, and there's also a very important federal law called, it's a very long name, called the Religious Land Use and Institutionalized Persons Act, also called RLUIPA. For RLUIPA, you can only bring a case seeking that ability to observe your religion. With the First Amendment, you can also seek a compensatory of financial money damages, but it's much easier to win your case under RLUIPA. And so just, you know, not only is it, you know, I want to be able to go to church or observe my religion on, you know, the sort of different religious practices, but, you know, do you require religious diet? Do you require other types of things? Are there prohibitions? All of these can count under RLUIPA. And just to flag, there are a few other things. You also have a freedom to be free of retaliation. You file a lawsuit, you file a grievance. These are acts protected by the Constitution. And if the prison retaliates against you, that is a violation of the Constitution. Now, once again, to prove it in court can sometimes be very difficult. So we always encourage people to keep a log. You should keep a log. You should, you know, again, keep a paper trail, and that can help. There is a little bit of a freedom of the press, but honestly, that's very, very difficult. The prisons and jails are given a lot of leeway on this. And you have the right to access the court. You have a right to be able to communicate with your lawyer. You have a right to get to court when you have a court proceeding. All right, and I just wanted to flag, if you believe that your rights have been violated and you want to bring a lawsuit, if you are still incarcerated, then you must file something called a grievance. And not only do you have to file a grievance, you must appeal it to the top level. So if you're in the Department of Corrections, that means filing your grievance to the grievance coordinator, appealing to the superintendent, and then appealing to central office. And you have to follow all the rules. You have to name, for the Department of Corrections, you have to name the people, put an amount of damages that you want, put in as many details. So county jails sometimes have 2 levels. So you have to read each one carefully. Federal Bureau of Prisons, very, very complicated. You have the informal, then you have the BB9, 10s, 11s. And, I fully acknowledge it's very difficult to meet those requirements. But if you want to be able to file a lawsuit while you're incarcerated, then you have to follow the grievance rules. The grievances can also help you if you, once again, we talked about notice. You're trying to get medical care. It paints the picture that you are really trying to get help. You're trying to resolve this issue. So by the time you get in court, you've tried everything that you can and you're resorting to this lawsuit. So it does have other benefits. Honestly, it is a very difficult requirement, but it is an important one. And if you have any questions about it, you can reach out to our staff and we will help, we can help you talk through it. So what I'm going to do now is I'm going to pass it over to Evangeline to talk about medical care. Yeah, sure.
On the last one, it says if you are still incarcerated. So do you lose, if you're no longer incarcerated and the case has not been adjudicated through the system, do you lose the right to continue with the case?
So the reason why I said it's incarcerated, if you are released and you're living out in the community, you want to file a lawsuit, actually, you don't have to fulfill that requirement, right, but you have to be within 2 years. So that's the challenge.
Within 2 years
of the incident. So there's, yes, so you have a statute of limitations issue. So for some people, if you know you're going to be released next week, next month, and you might have had some challenges. I mean, we know so many people have trouble filing those grievances and appealing, then you might want to wait and file it when you get out. The risk is you don't want to lose your statute of limitations. So that's why we put that there, because it only applies to people who are quote unquote prisoners. If you're released, you're no longer a prisoner.
See if I can get on camera here for the Zoom. A little tall here, scooch back enough. Can everybody hear me? Okay, good. I will try to keep my voice loud. If you're having a hard time hearing me though, just give me a little signal because I do tend to be a little soft spoken. So my name's Evangeline Wright, and I am delighted to be here with you tonight. I'm going to be talking with you about medical care for incarcerated people. And before we get into what medical care means in a prison context, we need to talk about what medical care includes to make sure we're all thinking of the same things. This is a non-exhaustive list. This does not include all of the issues that somebody who is incarcerated is going to encounter, but it's a pretty good sample of what somebody might experience and need care for. So we're going to talk about 2 questions in this portion of the evening. We're going to talk about where the right to medical care comes from, and then we're going to talk just a very little bit about what you can do to advocate for people who are incarcerated, if you have a loved one or a friend who's incarcerated, or if you happen yourself to be incarcerated, what steps you can take to help yourself in that situation. So the first question we're addressing, who says incarcerated people have a right to medical care? And the first place to look is actually right to the institutions themselves. Pennsylvania Department of Corrections, Federal Bureau of Prisons, they post their policy manuals and their inmate handbooks right on their website. It's widely available, and that defines in very large part the care that people are able to access. County jails have the same policies. These are all very rule-based organizations, but their handbooks, their policies are a little more difficult to access. They may not necessarily be posted on the internet or widely available, but it is something that can be requested. So there's a reason that institutions say, yes, we're going to provide medical care to people who are incarcerated. And that reason goes all the way back to the US Constitution. We as a society decided that we are not going to inflict cruel, unusual, and unusual punishments on each other, And we have decided that withholding necessary medical care is a cruel and unusual punishment. But we need to narrow that a little bit, because to get from no cruel and unusual punishments to a trip to the dentist to get your teeth pulled if you're incarcerated, we need to look at the specifics of that. So we look to case law, because the courts have really defined what that means in these situations to access medical care. And the case that a lot of medical care cases for incarcerated people look to is a 1976 Supreme Court case that established a deliberate indifference standard. And you heard Sue Ming reference deliberate indifference earlier in another context. Deliberate indifference is the standard for medical care as well. So the deliberate indifference standard, that requires two things. Requires that the medical need of the incarcerated person is sufficiently serious, and this is crucial, it requires that prison officials knew about the need and ignored an excessive risk to the incarcerated person's health and safety. And what that actually looks like, I'm going to tell you about a couple of cases so you can see how that might play out in a court context. So in one case, prison staff misdiagnosed a ruptured tendon as a sprain, and for 2 months, they refused care to the incarcerated person. The court ruled, yes, that is deliberate indifference. And in part, that was because of the degree of pain that that person experienced for 2 months. Another case where the court found, yes, this is deliberate indifference. An incarcerated person lost his dentures and suffered from bleeding and sore gums. Prison officials refused to put him on a soft food diet. He was unable to eat without pain for a period of time. The court said, yes, this is deliberate indifference. Contrast that, though, with a case where medication was withheld from an HIV positive person for a period of time, for several days. The court said that is not deliberate indifference. Prison officials could withhold that medication. There was no deliberate indifference. And the ruling was based in part on the court's decision that that person experienced no physical harm during the period that they were unable to access their medication. So to be clear, deliberate indifference requires something more than a medical malpractice standard. An incarcerated person suing under the 8th Amendment has to show something more than just medical malpractice in order to successfully litigate an issue. So if you're like me, you might be sitting there wondering, is it part of somebody's sentence when they're sentenced to be incarcerated to experience the possibility of medical malpractice? And the answer to that is no, but with a serious asterisk. Under Pennsylvania law, incarcerated people like you and I have the ability to sue for medical malpractice. But here's the asterisk. An incarcerated person, in order to bring a medical malpractice case, needs to first get a certificate of merit before they litigate that case. Certificate of merit has to come from a doctor, and the doctor has to say, yes, this case has merit. So practically speaking, for an incarcerated person to bring a medical malpractice case, getting that certificate of merit is going to be very difficult for somebody who is not represented by an attorney and is incarcerated. So the right is there, but with that very serious asterisk. So that brings us to a definition of adequate medical care that is really medical care without choices. You have the right to medical care, but that medical care, you're not going to get to pick a specialist. You're not going to pick the course of treatment. You're going to get the medical care that somebody says, this is what you're going to receive. You take it or you leave it. So as you can imagine, problems do arise and litigation needs to happen. And there's two types of situations where you can look at litigating. Sometimes there's a problematic rule. The policy, the handbook spells it out, and this is just a difficult rule. Sometimes the rule is okay, but the way in which it's being interpreted, the delivery of care, is problematic. So some examples of cases that PILP has litigated with problematic rules include the one good eye policy. For a period of time, the Pennsylvania Department of Corrections refused to provide cataract surgery in both eyes to people who needed it. If you were incarcerated and you had cataracts in both eyes, Pennsylvania Department of Corrections would fix one eye for you, but said you have no right to binocular vision. One good eye is enough. PILP successfully litigated that issue. Pennsylvania Department of Corrections now provides cataract surgery in both eyes. PILP has also done some litigation with access to hepatitis C treatment, some access to treatment for opioid use disorder. So those were rules that needed to be changed. The other types of issues that you see in a medical context for incarcerated people are situations where the rule exists, it's fine, but it's not being interpreted well. So we get a lot of contact from people looking for assistance with diabetes care, which is very difficult to manage in a carceral context, mental health care, and specialist appointments and surgeries as well. Yes, absolutely.
So I was talking to an incarcerated person who was no longer incarcerated. And they said that they were in federal custody and they had to have teeth removed. And the prison didn't provide Novocaine. Is that the kind of, when you describe the problematic rule, or no, when you say care without choice, are they able to inflict something which is obviously very painful?
Well,
Can you repeat the question, please?
yes, absolutely. So a gentleman in the audience here is asking about a situation in which somebody who was in federal custody had some teeth pulled and no Novocaine, I assume no pain treatment was
Right.
provided. That it's a very situational specific question. I think in some contexts, I think an argument could be made that it's within a standard of care depending on the teeth that were pulled. I think all of us sitting here in this room would say, no thanks, let's not have any teeth pulled without Novocaine.
Right.
Whether it would be a successful case depends on a lot of factors. So there's what the law says, there's whether you could be successful in court, and there's what we as a society say, which is we probably would not agree that that's a good standard of care. And we can return to that question later if you want to discuss it further. I want to move on though to what you can do to help. If you are the friend of somebody who is incarcerated, if you have a loved one who is incarcerated, because the advocacy of family and friends makes a real difference in the lives of incarcerated people. So if you take away one thing from this presentation in terms of advocacy, it's this phrase: be polite and be persistent, because that is the best way to get results. Specific things that you can do as an advocate for an incarcerated person: a phone call and a follow-up letter. And here's what that could look like. With your phone call, who you want to call, it's really going to come down to who is willing to speak to you. And you might just have to start out with whoever answers the phone. You can ask to speak to a healthcare administrator. That would be an excellent person to start with. You can ask to speak to a superintendent's assistant. That person will have a fair amount of power to make decisions. You can ask to speak to the medical director. It's a good chance you would not be able to. But if that's denied to you, start with who you can speak to and try to work your way up the chain from there. What you're going to talk about when you're on the phone with a prison official. Ask for the name and the title of the person that you're speaking with. Take notes. Ask questions. If that person can't answer your question, ask if they can put you in touch with someone who can. If they promise you action, ask for a timeline. Ask for when you can follow up with that person to see if the action happened. Be aware of any possible repercussions to the person that you're trying to help. You do not want to advocate so vigorously that you cause retaliation against that person. Also be aware that prison personnel are not going to tell you if someone is in the hospital, and they're not going to give you any specific medical information about someone unless you have a signed release from that person. Very importantly, you want to follow up with a letter. In that letter, you're going to reference the date of your conversation. You're going to address it to the person that you talked to. You need to summarize what was discussed, and you need to highlight any action that was promised and the timeline for that action. If you are a person who is incarcerated, there are some things you can do to advocate for yourself. You can speak up about your medical needs. Be very clear, be polite, be persistent. Keep a record of your requests. That paper trail, if you need to advocate further down the road, if you need to litigate, is going to be very useful to you. You're going to want to know the dates that you requested things and what specifically you requested. And finally, if it's available to you, and it may not be, but if you can make your outside medical records available to prison officials that may improve your care, particularly if you have an ongoing issue like diabetes or cancer care in which an outside doctor, prior to your being incarcerated, has prescribed certain treatment for you. Referencing that can be helpful in getting treatment inside. And with that, I'm going to turn it over to my colleague, Ricardo, because he has a lot of great information to share with you about public benefit.
I think I am in the picture frame now, so I will get started. My name is Ricardo Brownwit. I'm an attorney with the Pennsylvania Institutional Law Project, and I am happy to talk to you today about some of the issues that people sometimes face whenever they are coming back into society from prisons and jails, and how they can access public benefits and some of the issues that they face with barriers to employment. And so we are going to start off with talking about some of the issues with public benefits. And what we mean when we say public benefits here are programs like Medicaid and Medicare, programs like Social Security, programs like SNAP and TANF, all of these programs that really help people to enter society, to get back on their feet. And we are specifically going to be talking about incarceration's effect on a person's ability to access those public benefits. And so whenever we are talking about these programs, incarceration normally has some effect on most of these programs. And we are going to be focusing on some of the nexuses between the person's status and the person's ability to access those programs in the future and at present. And so we want to keep two questions in our head whenever we are talking about access to public benefit programs. We want to keep the question of, is this person incarcerated in our head? And we also want to keep the question of, what effect does incarceration have on eligibility and enrollment? And to go back to the first question, the reason why this is important is because every single program is going to have a very distinct and individual definition of what they consider to be incarcerated. And it is not always going to be as simple as whether or not someone is physically located within a prison or jail. And again, we want to keep this second question on our minds, because incarceration is going to have normally some effect, but it's not sometimes going to be as simple as complete blanket ineligibility or complete blanket disenrollment from a program. There's going to be a lot of nuances based on the specifics of the program that we are talking about. So let's dive into one of these programs, medical assistance, specifically Medicare and Medicaid. And here are some of the differences between Medicaid, which is a program that provides healthcare assistance for people that are low income and qualified because of other criteria, and Medicare, which is a medical insurance program for people that are over 65 and younger, disabled people, and some other categories of individuals. And so let's go back to question one. Is this person incarcerated for the purposes of Medicaid and Medicare? Who does Medicaid and Medicare consider to be incarcerated? These are people that Medicare and Medicaid do not consider to be incarcerated. And some of them are intuitive, like people that have not been arrested. There are other categories, like people that have been arrested but have been released, people that are on any kind of home tethering system, either house arrest or a person that is on probation or parole, people that are in juvenile forensic units. Those people are also not considered incarcerated. Additionally, anyone that is living somewhere voluntarily, you might think about like some of the community programs that people can be placed in as a result of conviction. If they are in some kind of community-based program, they might not be considered to be incarcerated for the purposes of medical assistance. And so let's go through some of the examples. So let's just pick example number 2. So person Y has been charged with shoplifting, and they've been brought to Lycoming County Prison awaiting trial. Is this person incarcerated for the purposes of medical assistants. And no, they're not. They haven't been charged. They haven't been charged, but they haven't been convicted yet. So they are not considered incarcerated. Person Z, the third example here, this person has been charged and convicted of simple assault, and they've been sentenced to several months of house arrest. So they've been charged, they've been convicted, but they're not considered incarcerated for the purposes of medical assistance. They're still eligible for the program, and incarceration isn't going to have any effect on eligibility here. So what happens if you don't fall within any of these categories? You have been charged, you have been convicted, you are living at an institution. What effect does that have? So we talked a little bit about the 8th Amendment standard for medical care. We know that if you are in these institutions, the institution itself should be responsible for providing you with healthcare. And that is the logic for the government saying that people are not eligible for medical assistance if they are incarcerated. But if a person has been convicted and they're living in prison and jail, then they are ineligible to access that program, essentially. But it doesn't necessarily mean that they are automatically kicked off. And that is because in Pennsylvania, if you have been incarcerated, then your medical assistance is not simply cut off. What happens is you have medical assistance that is suspended for a period of not more than 2 years. After that 2-year period, if you are outside of the that particular facility, then your medical assistance gets restarted. And so let's look at some of the examples of this. So let's go with person A. They enrolled in Medicaid in November of 2022. They were convicted at the end of November on a trespassing charge, and they are now 15 days into a 4-month-long sentence. At the end of that 4-month-long sentence, their medical assistance enrollment will not be affected. They will be out of that suspension period, and their medical assistance can restart. And that's important because we don't want people to have to do a lot of work to get back onto medical assistance after getting out of prison or jail. And it helps that person to be able to not have a gap in healthcare coverage. And so let's move on to Social Security. And let's talk a little bit about what Social Security is. Essentially, it is a program that falls within these 2 different buckets. There are a lot of eligibility requirements for Social Security, whether or not we're talking about SSDI or SSI. Here are some of the main differences between SSI and SSDI. SSDI supports people that are disabled and have a qualifying work history, either through their own past employment or an employment of one of their eligible family members. And SSI provides basic minimum financial assistance to people that are older and people with certain disabilities. There is a lot more to talk about with regards to both of these categories, but we are talking about incarceration's effect on these programs. So the first question here is still, is this person incarcerated for the purposes of these programs? So if you are talking about a person that has been convicted and sentenced to a period of confinement in a correctional facility, and they have been, based on that conviction, they remain in that facility for a period of 30 days or longer, that person is considered incarcerated. However, I think a lot of us might note that what does not fall within this category are people that have been charged. They are confined in an institution. However, they have not been convicted. That person is not considered incarcerated for the purposes of Social Security. However, there is a caveat there. And the caveat there is that if you are living in any kind of public institution for the purposes of Social Security, you can't receive benefits for that time period because you're considered a resident of that institution for that time period. And so here are some other categories of people that are considered not incarcerated for the purposes of Social Security. So it's very similar to the medical assistance programs where people that are placed on these tethering programs, for example, are not going to be considered incarcerated. People that are on parole or probation, they're also not going to be considered incarcerated. And with parole and probation, a question that might come up is what happens if you are in a prison or jail as a result of a parole violation or probation violation? And it's going to be the same thing for as like we look at for arrest. You are not going to be considered incarcerated until that parole or probation violation has been completely adjudicated and you have restarted your conviction, essentially. Also, just to go back, the last category there, eligible family members. That is a very important category when we're considering incarceration's effect on Social Security, because eligible family members are not considered incarcerated. And Social Security benefits can sometimes go to these eligible family members. And if you have one of these and you are incarcerated, your benefits might still be able to go to these family members, even though you yourself are considered incarcerated. Go ahead.
Case like that, for example, a minor child who is eligible for the Social Security. Does the Social Security Administration these people, or is it is the burden on the file? Or, do you understand my question?
Yeah. So there's a question about if a person has a eligible minor child that is receiving benefits, whose response, and this person ends up going to an institution and they're considered incarcerated, whose responsibility is it to notify the Social Security Administration of the person's?
Yeah, or does the administration usually make a point of notifying, or is that something that people should look out for their relatives and their?
This is also going to be like a case-by-case situation. However, the Social Security Administration normally does not stop those benefits. They have like their own caseworkers, and those caseworkers would evaluate the situation normally and determine that the minor child, if they were eligible and remained eligible, that the benefits never were discontinued. If it was discontinued, then that minor child would, or the person representing that minor child would then have to go and potentially pursue like a case with the Social Security Administration. There's another question.
Question about like down at CI Muncie, several women have been incarcerated and their children have been taken, that they've never signed anything since they've been there for several years. They're not have any rights to get them back or anything. Is that correct, that they can be taken away from their children can be taken away from them just because they're incarcerated for a number of years?
So I can.
Yeah, I think Humane might want to answer this question.
I'm just going to answer it quickly. We're going to otherwise fold the Q&A to the end. But basically, the question was for women who are incarcerated at SCI Muncie, there have been reports, I guess maybe you know, people whose their parental rights were terminated relating to their children. So under the law, the mere fact of incarceration does not permit termination of your parental rights. However, unfortunately, what I've seen is that local courts often will unduly take into consideration the incarceration. So you as the parent, when you're incarcerated, have to stay in touch with the child. But we know that sometimes there are barriers to you being done that, but legally you can't just do that. So it's really, really important. When you are a parent, you have a legal right to an attorney, because this is such a fundamental need to build a relationship with your child. I unfortunately have seen and heard of that situation. I had my own client that happened to him. And it was just devastating. So the answer is a little bit complicated. It shouldn't just happen, but more than likely they probably got no notice. They didn't know about the hearing. Technically, there must be a hearing before your parental rights can be terminated.
That was a good question. So continuing on, what effect does incarceration status have on Social Security? And the effect is for a person that has been incarcerated for a period of 30 days or more, the payments are suspended for that time period. And if a person is incarcerated for 12 months or longer, then the Social Security eligibility will be terminated. And that means that a person who has their eligibility terminated, they now have to apply again for Social Security and completely restart the application process. And let's go to the application process. When a person is incarcerated, they can and they should begin to submit their application for Social Security if they are otherwise eligible while they are still incarcerated the minute that they have a release date. In general, there are some policies that say that whenever they have a release date within 6 months or so, that is when they should begin applying for benefits. And certain institutions within the DOC, for example, they have pre-release agreements with local social security offices where they can go and inform those offices that like the person is going to be released, or a person is going to be released, and that person is eligible for benefits, just to get those benefits to restart whenever the person leaves the institution. And here are some other benefits that a person might be eligible for, where incarceration will likely have some effect on either one of these categories. But we can talk a little bit about those categories and these programs after we're done here. And so let's move on to barriers to employment. So whenever a person leaves an institution, one of the things that they face very often is concerns about finding a job. And one of the ways that they can sometimes relieve some of those concerns is if they can get their criminal record history sealed or expunged in some way. And so there are three main methods of getting your records sealed or expunged in Pennsylvania. There is obviously expungements, there are limited access programs, and there's the clean slate limited access program. And so let's talk about some of the differences between these three programs. Expungements are the best way, essentially, of getting your record cleared, because expungements, as opposed to the limited access program, and as opposed to the clean slate limited access program, expungements actually gets rid of the record entirely. Whereas limited access programs and clean slate limited access programs, these are ways of getting your record sealed. I apologize, I'm losing my voice a little bit. Let's hope that I can continue through the, what? No, I don't think it might. I don't think it will help. But thank you. So with expungements, expungements are very, very limited. And so expungements are filed pursuant to a petition. You have to ask the court to get your record expunged, and only certain types of offenses can actually be expunged from your record. And here are the three main categories. There are others here that are available, but here are the three main categories that of offenses where you can get your records expunged. The number one category is for summary offenses, where a person has been free from conviction for 5 years. And here I'm just going to stop and explain what conviction means here, because it is a term of art that is specific to expungements and specific to limited access programs and clean slate limited access. Conviction means specifically a conviction for something more than a summary offense, or something more than an ungraded misdemeanor. So in the first category, if a person has been free from conviction for 4 years, and then they get another summary offense, that summary offense conviction, if they are charged and convicted of it, is not going to be considered a conviction for the purposes of expungement, and they are still going to be eligible for the program. And here are the other two categories for a person that is at age 70 or above, where that person has been free from arrest or conviction for 10 years, or for a person that has been dead for 3 years. These are also categories of people that can get their records expunged. And how do you do this? You do this by submitting a petition with the court, with the clerk of courts, where the charges were first disposed. And these petitions are widely available online. You can also sometimes get these petitions through the clerk of court itself if you go to the courthouse. And so what is limited access? Limited access, as opposed to expungement, it is a program whereby you can get your records sealed. And this also is going to require a petition. And what do we mean when we talk about getting your records sealed? We are talking about making sure that your records, your criminal records, are unavailable to anyone except for essentially these three types of agencies: criminal justice agencies, state licensing agencies, for example, I'm an attorney, the bar, the Pennsylvania bar is still going to be able to see whatever kind of record that any attorney has, essentially, even if you get it sealed through the limited access program or the clean slate limited access program. And so let's move on to what kinds of records can be sealed through limited access. Ungraded felonies punishable by under 5 years. Some misdemeanor 1 convictions. There are a lot of carve-outs for both limited access and expungements, and also for clean slate limited access programs. And then misdemeanor 2s, 3s, and ungraded misdemeanors. These can also be sealed through limited access. Within all 3 of these categories, there are, again, carve-outs for certain types of crimes. And then how to, you can also, you need to petition to access the limited access program. And it is this particular petition. And you also need your original Pennsylvania criminal history record and all of these other documents. And so clean slate limited access, as opposed to the other 2 programs, is completely automatic. You do not need a petition to access this program. If you meet the eligibility requirements, then that is it. And here are the 3 general categories of types of records that can be sealed through the clean slate limited access programs. Misdemeanors that are grade 2, misdemeanors that are grade 3, and ungraded misdemeanors. And again, you're going to have those carve-outs for the different types of misdemeanors that are just, regardless of grade, they are not going to be eligible for expungements, clean slate limited access, or for the limited access program. In addition to this, there are types of people that are going to be considered ineligible people. For example, you need to be 10 years conviction free before you're able to access the clean slate limited access program. You also cannot have any felony convictions or any enumerated convictions in this particular section of the Pennsylvania Criminal Code. And those are going to be, again, your crimes of violent sex and other certain types of crimes. And so last but not least, I'll just touch on ban the box. If you are not able to access any of these other programs, you're not able to access either expungements or any of the limited access programs, one of the ways of getting employed and getting your record and not having employers look at your records before they offer you a job is through ban the box programs. This is essentially just like a way of preventing employers from asking about your records until they offer you the position. They're somewhat available in certain counties. For example, Philadelphia County or Philadelphia has a ban the box program, and statewide, you're really going to be talking mostly about a policy within Pennsylvania that prevents Pennsylvania state agencies from asking about your criminal record history until they offer you employment. And so if you are not able to access those other 3 programs that we just talked about, ban the box is one of the ways that you can sometimes still find your way into employment. And that is all for me.
Well, that was a lot of information we just received. My name is Chester Holman, and I actually work as a legal assistant in the Philadelphia office of the Institutional Law Project. I've been with the project now since March of 2020. But prior to that, I had been incarcerated for 28 years, where falsely, but I served 28 years in prison. I came home in 2019, and August of 2019, I was exonerated, and I came home in July of 2019 and exonerated in August of 2019. I'm still trying to process a lot of this information I just heard, because, you know, the time that I spent in prison, these are the things that I was not aware of. Because from the moment you enter into prison, these are the things that, you know, that they're tucked away.
and you are told that you have no rights. Life is over, and we run this, and you are state's property. So I was very unaware of any of these things. I just thought it was the norm. You know, clean cells, rights to phone, showers and stuff. I just, even medical assistance, I was totally unaware. And I've been home 3 years now, and I'm just now learning this stuff, and I still didn't know. You know, Saming was talking about, you know, we're not talking with one mice. I mean, I had multiple mice would crawl on me every night, and I would be tucked under this sheet, and I just feel these mice crawling, and I just, you know, I just thought that was what life was supposed to be in prison. There was an incident where I had tore my Achilles in prison and ripped clear off the bone and broke my ankle, and I went to medical, and they gave me Motrin and told me that I had a high ankle sprain. And I walked around dragging my leg for almost 3.5 weeks. And finally, I just couldn't take it. And I just said, you know, I went to the health administrator, Mr. Mataloni, and I told him, I said, I got to call my lawyer. And after I said that, I was taken out that next morning, and later on that night, I was given surgery and had my Achilles repaired and so forth. But these are just things that, like I said, I'm just listening, and like, how would you ever know? I mean, you can't fault someone for not knowing. If you don't know, you don't know. And I'm really at a loss for words, because all those years, my 28 years, I just thought that I wasn't entitled to anything, because I spent so much time trying to fight my case, you know, because I'm in prison for something I didn't do. So I'm worried I'm fighting the criminal aspect of it. And, you know, I didn't realize that I had all these different rights, you know, and to hear of it now, and the things that I've learned over the years while I was there, you know, people just don't know. And there's a lot of guys in there who don't know. You know, we're given medication that is, like I said, the number one medication is Motrin. For everything, you receive Motrin. You know, you got a headache or a broken arm, you know, ruptured spleen, you get Motrin. And you know, and it's sad, you know, and you know, they don't separate the guilty from the innocent in prison, because you're all considered guilty. So we're all together in this one flock. And you know, even though, you know, I was there, and I knew I didn't do the crime I was there for, I was still treated as a guilty individual, and treated the same as someone that was guilty. And like I said, you know, the medical there, it was just horrible. And you know, and I came home in 2019, still unaware of the things that I was eligible for, because, like I said, I sought out, you know, programs that could help me reintegrate back into society, and even with health benefits, you know. And because I wasn't considered on parole, I was now exonerated. I was actually considered a free man. There were no programs available to me. So after about 8 months, I finally was able to get on Medicaid, and you know, it's been a journey. And you know, I've been to the doctors a few times, and just recently, I just got off of Medicaid. And you know, you know, I'm giving a little bit of information here, but you know, I was given millions of dollars in my lawsuit a couple of years ago, and I have all this money, and you know, I'm still on Medicaid. So you know, I didn't know what to do, and I felt bad about it. So I got off Medicaid, and I'm going to these doctors, and I'm paying out of pocket because I just didn't know. You know, and these are the things that we're unaware of. So it's organizations like Pennsylvania Institutional Law Project that really, you know, bring these things to the forefront, because, like I said, when you don't know, you don't know. And you know, I just, even though I'm an employee of the project, I just want to say I commend Suming, and you know, Evangeline, and Terrell, and Ricardo, and Sierra, the whole entire staff here. I mean, I've been here, and I sit back and I'm just in awe of the things that I've seen, and the way that these people care. You know, it's amazing. And I just really feel very proud, because I don't necessarily need to work, but at the same time, I feel like it's an honor for me to be amongst these people, to be working for this organization. And that's why I still stay. That's why I'm there. You know, whether I get paid or I don't, I'll be there, because it's a great organization, you know, and it's some great people that are there. So, you know, I just want to say thank you for the work that you do, and even for this event here. You know, it shed a lot of light you know, for those who are watching, for those that's here, and even for me. And I was there almost 3 decades, you know, so it's, to learn this stuff, you know, I'm going to go forward. And like I said, it also humbles me. It helps me to become a better person, you know, knowing that I can perhaps take this information and share with some of the guys that I know that are still there, that I keep in contact with. So, you know, I just want to say thank you for the work that you do, and thank you guys for coming. You know, it's been an honor to be here. Thank you.
Thank you very much, Chester. That was incredibly moving, and thank you. I really appreciate it. And I want to give a special shout out to you, Chester, and you, Terrell, for being a part of our staff, because of your lived experiences are just incredibly valuable to us as we work with our clients. So it almost seems funny to go into the Q&A, but I do want to address some of the questions that were raised. And I apologize, I just have to do it through the laptop here. Actually, I'm going to throw the first one to Evangeline. The question was, actually, why don't you stand up here and I'll read it. What is the obligation of the prisons to follow the recommendations of specialists?
Okay, so that's a great question. And actually, I happen to have a case site for you because that's what lawyers do, right? And like I was saying earlier, you look to the Constitution for where the right comes from, but you look to the courts to tell you what that right actually means. So courts said deliberate indifference can be inferred based upon a medical professional's erroneous treatment decision only when the decision is such a substantial departure from professional judgment or standards as to demonstrate that the physician didn't base a decision on such a judgment. So that's court speak. What that actually means is, if you have cancer and your prison doctor gives you sugar pills, that's deliberate indifference because there is no medical standard that says that's okay. But if you have a specialist that says, I think you need to do chemotherapy and then we can consider surgery, your prison doctor says, let's go straight to surgery. That's within medical standards. If it's within the standard of care, if there is medical standards somewhere that says, yeah, that's kind of an okay treatment, that's something we do, then that decision can be made by your prison doctors.
So I'm going to take some of the other questions that are sent through the Q&A. I'm going to stick with the medical ones first. So the question is about an incarcerated person who has a disability, and specifically ASD and MDD anxiety. Is that person entitled to medically necessary mental health therapy from an outside therapist that they were a client of prior to being incarcerated? So we sometimes get this question, can you basically go to the medical provider that you were seeing prior to being incarcerated? And generally the answer is unfortunately no. You do have the right to get adequate medical care, but you do not really get to choose who your medical provider is. As Evangeline had said in the beginning, you're kind of stuck with whatever the prison or jail has given you. And we know sometimes that might not always be to your satisfaction or perhaps worse. But that is, unfortunate. And I totally get it, right? In the mental health context, that relationship that you have with your therapist, your counselor might be really important, and to have to change, especially to someone else who, we unfortunately get all the bad stories while in our line of work, but you do not unfortunately get to go to someone that you were going to before. All right, so let me just mark that. I think there was another question about mental health. It seemed like the Pennsylvania Department of Corrections was limiting hold time, which is time in solitary confinement for decode folks, to 30 days. But the comment is SCI Phoenix is not currently doing this. And does this vary? So, and is it protected by law? So the law, again, sometimes the law can be very squishy. There's a prohibition against cruel and unusual punishment. That means we now know that solitary confinement is detrimental to people's mental and physical health. But the exact time frame is not really outlined in the law. However, in Pennsylvania, there is a settlement in the case called DRN versus Wetzel, and PILP, along with several other organizations, reached this settlement that does limit time in the hole to 30 days. We do get, unfortunate reports that isn't always followed, and it might, sometimes we get reports that people's code gets changed to get around this. So it's not, it is, you know, at the time the settlement was incredibly important, but we now also know that there are limitations to that. What I would encourage you to do is to reach out to PILP if you think there's a specific issue, and write to any of us. You know, either the person can write to us, or if you want to call the office. And then there's a question about sort of immigration detention. If a person with an immigration detainer needs a medical procedure, but that's not an emergency, and the petition is detained, and I mean, the petition is delayed with the argument that he or she will soon be deported, can that person file a grievance? And there's another question about what happens if a person is deported, can they still file grievances? So I'm going to answer this more broadly, which is immigration detainees are entitled to the same, if not more, protections that incarcerated people with criminal convictions have. It is now established that immigration detainees have the same rights as other incarcerated people, and especially pretrial detainees. In terms of medical care, unfortunately, we do see things getting delayed, thinking that person will be deported. I don't think that's right, but we do see it. And it can get a little tricky because of, you know, in terms of the actual person, it will depend on the medical condition. Is it something that is urgent? In that case, our position is that immigration detention center, and oftentimes it's a prison or jail, is obligated to provide that, and they should not delay it. There are some times when, you know, something's like a several step process and you can wait, then under the medical standards, maybe it's okay. But if it's an urgent situation, really that person should be provided the medical care. In terms of a grievance, so when you are an immigration detainee, you can file a grievance. You follow the same rules as that institution. However, an immigration detainee is not obligated to file a grievance in order to file a lawsuit. And that is because they are not a quote unquote prisoner under the law. They are being held for administrative purposes. Now, I know a lot of immigration detainees call it prison, and they are, you know, if you're in your county prison detained as an immigration detainee, you're in the same jail. But legally, you're not a prisoner, so therefore you actually don't have to file that grievance. But it might be helpful, right? Sometimes that's your only avenue to make a complaint. So, so you can use that avenue. All right. So, have a bunch of questions. Let's see. I'm gonna just go a little bit. Do letters to the prison administration have to pass through the Florida copying system that letters to prisoners must pass through? So as you may know, the Pennsylvania Department of Corrections in recent years set up this new mail system, which I don't think is ideal, but it goes through Florida, and you send your mail to Florida and they scan it in, and then the prison itself prints it out. Legal mail does go directly to the institution, and make sure that happens, because legal mail is protected by the First Amendment, and you have a right to attorney-client privilege. But if you're writing to the prison administration, let's say you want to write to the Secretary of Corrections, I actually don't know, but I would say mail it directly, because, and I'm seeing Sierra nod her head. So, because it's not to an incarcerated person, it's to someone at the administration. So go ahead. And in fact, you know, as I think Evangeline said, I always recommend, if you as a friend, family, loved one of an incarcerated person, you can be an incredibly strong advocate. So you can call, advocate, be polite and persistent, as Evangeline had said. As a lawyer thing to do is, after you talk to someone, you write a letter, you keep a paper trail. And so I would mail that letter directly to either the person you spoke to, or, you know, someone there. There's a question about MOUD and MAT, so I want to address that. There was a recent ruling from the Department of Justice regarding access to medication for opioid use disorder, often, traditionally called MAT. And so what is a person's rights, incarceration person's rights, when that's not followed? So what I would encourage you to do is, that is a new project that we have. So please do get in touch with us. And I'm gonna say Sarah Bellos is our main contact. She's an attorney in the Philadelphia office. And she can work with you or your friend or family member to work through this issue. But it is our position that if you're on it, you have a prescription, you should be continued. We do know that many places do not. And we recently did a study of every single county jail and to kind of see where they're at. So we know there are a lot of problems, so please do reach out to us on that. All right. A question about SCI Cambridge Springs, women in wheelchairs suffering due to landscape hills, doorways, and how can the prison address this? So once again, the ADA does cover prisons and jails. So the prison must make accommodations. Now, there is it has to be reasonable. So if for some reason doing construction is going to be overly onerous, they don't have to make every single building accessible, but they do have to make the programs and services. Like if that person needs to go to chow hall and to eat, that it has to be accessible. So there has to be some way. And it might be that they would be transferred to another unit. It might be, so it just kind of, depends on the actual structure. So again, if you do know someone who has that issue, then you can, please reach out to us. Okay, so there's a question on, there's some more specific questions that are in the Q&A that I'm not sure we have all the responses to. I'm sorry if I missed any. What we're going to do is, if we didn't answer your question directly, feel free to reach out to us. You can contact each office, either writing or calling, or we do have a general email, pilp@pilp.org, or I think it's intake@pilp.org. And then we'll direct that to the appropriate person. And I just want to note that it is very valuable when friends and family reach out to us to give legal advice. We often do need to hear directly from the person, just lawyer rules. So just know that sometimes we say, well, can that person reach out to us directly? And we can't really take action without the permission of the person who's incarcerated, just because they're in the best position to know. Sometimes we want to do advocacy, but that person may be at risk of retaliation. So we want to make sure we have a discussion with them about what they want to do. But once again, you as the friend or family member, you're also, you can refer them to us or at least ask us about next steps. So I think that is it for us. I don't know, Terrell, if you have any last words. All right. Well, thank you so much, everyone. We really appreciate your coming both online and in person. And what we're going to do is